learning objective. Learning outcome. After this chapter, you can articulate the many factors that business owners must consider when starting a business entity. When start up the business entity, there are too many factors for the business owners to consider. Okay? Therefore, we will discuss these factors. Number 2, we will discuss the method, legal method, through which sole proprietorship entity and partnership entity may be capitalized. Capitalized means the funded. Funded means the borrowing the money from the bank or from the creditors. Number 3, we will discuss the elements that is required to form a general partnership. There are too many types of partnership. Okay? Legal elements that is required for forming a general partnership and the statutory requirements for being a limited partnership. General partnership or limited partnership is a different business entity. Additional type of partnership is a limited liability, limited partnership, limited liability corporation, professional partnership, family partnership. You will learn this additional type of partnership on chapter 15. Number 4, we will discuss the effect and law of devised Uniform Partnership Act for the general partnership and the devised Uniform Limited Partnership Act for limited partnership. Each state, there are 50 states in the USA. Each state has a legal authority to establish their own state law. Therefore, federal government established the Uniform Partnership Act. Some state adopted, most state adopted the Uniform Partnership Act. Number 5, we will discuss the difference between personal liability, individual partners liability for the general partners and limited partners. There are 2 types of partners, general partner and limited partner. These 2 types of partnership has a different liability for the debt and the loan of partnership. Okay. Number 6, we will discuss the difference between the consequences of partner separations versus dissolution of partnership. partners separation, dissolution of partnership is a different concept. Number 7, we will discuss the law of the franchise in business. Okay. Chapter overview. You can see this chapter overview on your textbook, page 68. Okay. This chapter introduces the why concept of a choice of a business entity. And then this chapter 14, gives the specific coverage to the law of sole partnership, sole proprietorship, and partnerships. And this chapter covers the fundamental principles of the law that is governing the sole proprietorship and covers the legal regulation for formation of partnership and governance of partnership, including personal liability of partnership for the business debt and other business liability. Finally, this chapter covers the rules that is governing the separation of partners from the partnership and the procedures for dissolving a partnership. A difference concept. Partners separation is referred as a dissociation under the legal terminology. Under the legal perspective, the term, different two terms, dissociation is referred as separation of partners, and the dissolving of partnership is referred as a termination of a business entity. Similar language, but different legal concept. Choosing a business entity, choosing a form of a business entity is very, very important, because the business owner's liability and business owner's control over that business entity is different among the many forms of business. Too many forms of business. Therefore, after graduate, the school, everybody must, most students start of the business. Then start of the business, you must consider the what type of a business entity is more suitable, more benefit for me. It depends on where you want to go. In choosing a business entity, the owners, principal owners, must consider at least the following 5 factors. Formation of business entity. Formation, some business type is very difficult to formation, but some business type is too much easy to form a business entity. Therefore, principal owner must consider the factors such as the formation and liability of the owners and the capitalization of business entity and income, business entities income tax. Finally, owner must consider the management of a business entity and the operation of a business entity. Therefore, not easy to choose a business entity when you start up the business. Okay, first type of business entity is a sole proprietorship. Sole proprietorship has only one individual owners. And sole proprietorship is an extension of its individual owners. It is very, very easy to form sole proprietorship. And it is very, very easy to maintain the sole proprietorship. Therefore, sole proprietorship is a very, very popular choice. When start of the business, most proprietor choose sole proprietorship because it is very, very easy of formation and maintenance. Sole proprietorship is not a legal entity. Therefore, sole proprietorship cannot sue or cannot be sued. Therefore, the creditors, such as bankers and vendor and claimant, sue the individual owner, individual proprietor, instead of sole proprietorship, cannot sue the business entity, but can sue against only the individual owners. That is the sole proprietorship. Sole proprietorship are typically capitalized, typically funded using a proprietor's individual personal resources or through the private bank loan or through the commercial loan that is secured by the proprietor's personal asset. Sole proprietorship business is not subject to corporation taxes. Therefore, cannot pay the business tax to the federal IRS. And sole proprietorship cannot file. Does not need to file the business tax return on behalf of the business. Why? Because business taxes directly flow through to the owner. This is an advantage. What is the disadvantage? The chief disadvantage to this form of entity is a complete lack of protection of the principal's personal asset for unpaid debt and liability of the business. Therefore, the owners must bear all risk of losses of the business entity. Termination. So proprietorship is terminated either by the express act of the principal, or sole proprietorship is terminated by operation of law in the case of the owner's death, or in the case of personal bankruptcy of the proprietor. Okay. Partnerships. A partnership has two or more owners. Owner is referred as a partner. And these partnerships take several forms: general partnership, limited partnership, limited liability partnership, limited liability, limited partnership, professional partnership, family partnership, several variations of partners. Each partner has a different legal effect, has different income effect, business tax effect. General partner, or limited partner, limited liability partner, limited liability, limited partnership, and professional partnerships. A partnership is a legal entity but partnership is not a federal tax-paying entity. What does it mean? Partnership do not need to pay the business tax to the federal IRS. Partnership is not a federal tax-paying entity. Therefore, all income or all losses from the partnership must be reported on the individual partners' federal income tax return, whether or not partnership income is distributed or not, or partnership's income is allocated to the partnership. Okay? Under the partnership tax return, all the income are passed through to the Schedule K1 of individual partners. When individual partners receive the K1 schedule from the partnership, in that, after that, individual partner can file his individual tax return to the IRS. Okay, general partnership. Uniform Partnership Act, UPA, is established in 1994 to govern all 50 states partnership business entity. This Uniform Partnership Act is revised in 1997. This revised Uniform Partnership Act is a model partnership statute. UPA stands for the Uniform Partnership Act. Uniform. What is the uniform? Because federal government unify the all 50 states partnership act. Therefore, Uniform Partnership Act. Uniform Partnership Act provides the governance of business partnership in several U.S. states. Louisiana state does not adopt this Uniform Partnership Act, but most states adopt this Uniform Partnership Act. In the absence of an agreement between the partner, revised Uniform Partnership Act governs, control the general partnership. Revised Uniform Partnership Act of 1997 defined the partnership as an partnership is an association of two or more persons, association, two or more owners to carry on as co-owners of business in order for achieving the proper profit. To obtain the income. Okay? That is the definition of a partnership under the revised Uniform Partnership Act. Every state has enacted partnership law, but very, very similar to the revised Uniform Partnership Act. Okay. Unlike most business entities, general partnership are not created, are not formed by filing a form with the government agents. Normally, when creating a business entity, the agent must file the form to the Secretary of State. However, general partnership are not required to file a form with the Secretary of State. Okay. Instead, the revised Uniform Partnership Act recognized two or more principles as being a general partnership. If they have intention, if they have demonstrated the intention to carry on as co-owners of the business for profit. For being a general partnership. I told you, no formal document and no formal government filing is required to form a general partnership. Fundamentally, a general partnership is an association, two or more people who are co-owners or as a co-managers and the partners shares in the profit of an ongoing business operations. The partnership typically use the designation of a general partner at the end of the business name in order to signify the general partnerships as their form of entity. What does it mean? There are two types of partner under the general partnership. General partner and limited partner. Only general partner can control, can manage the partnership. Limited partner cannot control, cannot manage the partnership. Therefore, when forming a partnership, it is required to designate the general partner at the end of the business name. Liability of the partners, owners, or principals, liability of the principals. General partner have no protection of their personal asset for unpaid debt and unpaid liability of their partnership. Therefore, if partnership cannot pay the money, in that case, general partner pay the money to the creditors with the partner. The general partner's liability is very, very heavy. However, limited partner has no such liability. Okay? Revised Uniform Partnership Act enforced additional liability on the general partners. General partners are jointly liable for the unpaid debt and liability of the partnership, and general partners are severally liable for the unpaid debt and liability of the partners. What is the meaning of jointly and severally liability? Joint and what is the meaning of joint and several liability? This means the general partners' personal assets are or at least for full amount of debt and liability of a partnership, jointly and severally, regardless of their percentage of ownership interest in the partnership. What is the meaning of jointly? Jointly means, joint liability means that all general partners are together, all general partners together are held liable for unpaid debt or liability of the partnership. What is the meaning of several liability? Several liability means that severally means the general partner, each general partner, and every general partner separately are liable for unpaid debt and liability of the partnership. That is the meaning of a joint and several liability. Very, very important concept. General partners' liability or total liability and crimes What is the meaning of a tort? Tort is a civil liability. Crimes is a criminal liability. What is the meaning of a tort? Tort means wrongdoing, wrong behave is a tort. Everybody has a legal duty not to harm another person in our society. If you harm or if you damage against other people in our society, it means that you committed the tort liability. In that case, damaged people can sue you based on the tort liability. In that case, you must compensate the damaged persons with your money. Okay? Partners and the partnership are liable when a partner committed a breach of trust. Breach of trust means the fiduciary duty. Violation of a fiduciary duty is a breach of trust. When a partner committed the breach of the trust for the partner's negligence. 3 types of torts: intentional torts, negligence torts, strict liability torts. Generally, partner and partnership are not liable for the individual partners' intentional torts. When a partnership and the partners are held liable for the partners' torts, partners may recover the amount of their vicarious liability from the wrongdoing partner. Vicarious liability. Because partnership, each partner is an agent of the principal partnership. Agent liability directly go to the principal. Okay? Therefore, that is the meaning of vicarious liability. Capitalization. General partners are generally funded through the debt. Generally funded by borrowing the money from the bank or selling all their equity. What is the meaning of equity? Asset minus liability equal equity is the principal equation of financial accounting. However, under the partnership accounting, equity is calculated by partnership income minus partnership liability equal ownership liability. Individual partners, individual right, individual ownership is referred as an equity. Okay? Each partner can sell his or her equity to other persons. Okay? By selling his or her percentage of ownership right in the partnership. through the selling, partnership can capitalize. Partnership may not, however, sell ownership right through the public market. Only a public company can sell the stock ownership right to the public market. It's very difficult to become a public company. Taxation of partnership and principles. Just as in the case of sole proprietorship, a partnership is the same as the sole proprietorship. Why? Partnership is a pass-through entity. What is the meaning of a pass-through entity? This means that the partnership entity do not need to pay the corporation income taxes, does not need to pay the business taxes to the IRS, just like a sole proprietorship. That is the pass-through entity. All income tax of business pass through the partnership and is distributed. All income is distributed to the individual partners on the K1 schedule K1, and all income is paid. All income of a partnership is paid at the individual partners' tax rate of receiving partner. Okay. Partnership taxation is complicated and difficult for the new students. If you understand, if you wanted to know the partnership income taxes in advance, you must learn the financial accounting. Next topic, next issue is operation of the partnership and management of the partnership. In absence of a partnership agreement, in case of there is no partnership agreement between the partners, in that cases, devise uniform partnership act governs, control the certain internal operation of a general partnership. Okay, partnership act control the partnership. For example, unless the parties agree otherwise, each partner will receive equal share of partnership profit regardless of partners' involvement in the operation of businesses. Same rule applies to the losses. General partners have a general power to buy the partnership. Only general partner. A general partner is just like a president, CEO, okay? A time management. Therefore, general partner has a general power, has a legal power to apply the partnership. Fiduciary obligations. Revised Uniform Partnership Act set out this fiduciary unit as three-fourths. What is the meaning of three-fourths of fiduciary obligations? It means that general partners have the fiduciary duties of loyalty, have a fiduciary duty of due care, and have a fiduciary duty of good faith that ensure a general partner must act in the best interest of the partners. General partner does not act for his individual interest. Instead, general partner must act in the best interest of the partnership. That is the fiduciary obligations. Uniform or limited partnership act. We learn the general partnership. Next type of partnership is a limited partnership. Limited Partnership Act control the limited partnership. Okay, only Uniform Limited Partnership Act of 2001 applies to the limited partnership in the United States of America. The limited partnership form is perpetual, continuously perpetual, and used primarily in tax sheltered ventures, tax saving ventures, real estate ventures, oil, gas, drilling ventures, and professional sports businesses. Limited partnership is used for this type of businesses. A limited partnership. A limited partnership is an entity, business entity that is existed by state statute that recognize this state statute recognized one or more general partner owners as a general partner who is managing the business enterprise with unlimited liability. Therefore, a limited partnership consists of at least one general partner and at least one limited partner. Limited partners normally participate only in terms of contributing capital or contributing the profit, and limited partner have limited liability. Formation of limited partners. A limited partnership is formed by the general partner A limited partnership is created by the general partner who is filed a certificate of limited partnership with the state government authority. Personal liability of the principals. Each general partner in a limited partnership is personally liable for all of the partnership's debt and liability. Limited partners, however, limited partners do not have the same automatic personal liability of the general partner, because a limited partner is limited to whatever the limited partner contributed to the partnership. Capitalizations of limited partnership. Our limited partnerships are generally funded by borrowing money from the bank or by selling the partner's equity. Taxation of partners and partnerships. A limited partnership are pass-through entities, just like general partnerships. The same rules of general partnership apply for the taxation. As in general partners. A general partner is responsible for filing an information return with the Secretary of State, with IRS, federal level, or with the franchise tax board on the state level. But a limited partnership do not pay the business taxes, corporation taxes. Management of limited partnership and operation of limited partnership. Under the revised Uniform Limited Partnership Act, or limited partners may engage in consulting and contribute the expertise, but may not engage in management activities such as controlling of employees or supervision of employees. United States versus Morton is a famous case for the limited partnership. Please read these cases in your home, okay? Family or limited partnerships. A family limited partnership is a partnership that is used for estate planning for families of considerable wealth. Wealth means the legal value, valuable thing is wares. All valuable things is recorded as wares. The legal procedure governing the family limited partnership transactions are very, very complex area of tax law and estate law. Okay, partner dissociation and dissolution of the partnership. When a partner no longer wish to be a partner, to be a principal in the partnership, then he or she may choose to leave the partnership. I wanted to leave the partnership. I do not want to imbibe the partnership anymore. In that cases, the revised Uniform Partnership Act used the term dissociation. Okay, dissociation means the act of separation. Okay, revised Uniform Partnership Act used the term dissociation to describe this act of separation from the partnership. Separation from the partnership is referred as dissociation under the partnership, general partnership. However, under the limited partnership, withdrawal is used. Legal term withdrawal is used instead of the dissociation. Okay? Same meaning, however, different terminology. This dissociation and withdrawal is an action of separation from the partnership. However, dissociation is used under the general partnership. However, withdrawal is used under the limited partnership. Dissociation under the limited Uniform Partnership Act. There are 3 events that triggers dissociation of the partnership. First event is partner want to voluntarily separate from the partnership. Second event, expulsion by unanimous vote of other partners. 100% agree to expel the some partner. In that cases, the partner can separate from the partners. Third event, partner can no longer carry out his or her duty to the partnership, or no partner no longer has an economic stake in the business. Stake means the interest. Withdrawal on the device Uniform Limited Partnership Act. Uniform Device Limited Partnership Act set out default rules for withdrawal of partners if no written agreements. A general partner may withdraw provided that the partnership still has at least one remaining general partner and the partners agree in writing to continue the businesses. Limited partners are subject to the restrictions on the withdrawal. There are other events or dissolutions. Dissolution means the termination of the businesses. Cross down. Okay? Wind up. Termination. These are dissolutions. Once a partnership has reached its agreed upon term, such as certain date set out in the filing or partnership agreement, or by court order, the judge order the general partner, your partnership committee, the wrongdoing committed criminal. Therefore, you must cross your partnership. In that cases, the partnership must be dissolved by the court order, or in the case of general partnership, by unanimous consent of the partners. Unanimous consent. 100% consent of the partners. Partnership can be terminated. Franchise. Franchise is a method, business method, rather than a business entity. A franchise is not a business entity. However, franchise are the business method. Legal right. Franchise is a legal right, not an entity. Okay? Franchise are method of conducting the business and not a business entity. Under the franchise agreements, franchisors enter into the contractual agreement with franchisees that allow the use of franchisors business model, use the franchisors business secret, franchisees can use the franchisors expertise, franchisors trademark, franchisors products, and so on in operating the business. This picture is a McDonald's. McDonald's had a lot of franchise. Franchise agreements governs the relationship between franchisees and franchisors by covering the term of the agreements, franchise fees, payment term, territory-wide, excludes geographic area in the business, training, support, advertising, franchise, operating protocol, royalty, fees that franchisee must pay, and franchisee termination and cancellation. Franchise regulations. Federal Trade Commission regulations are primarily designed to ensure full disclosure of all information relating to the franchise company prior to franchise investment. Most states have implemented their own individual franchise rules and minimum disclosure requirements to supplement the federal regulations. Okay, we finish the lecture, and I'll teach you some the testing slide, but true and false questions. Okay. The revised Uniform Partnership Act is a modern partnership statute. True or false? True. The partnership is an association of two or more persons to carry on as co-owners of business for profit. True or false? True. Partnership capital. Capital means all of the staff that is used for operating a business is defined as a capital. Partnership capital belongs to the individual partners in equal shares. True or false? False. Not equal share. Okay? Can be equal share and can be not equal share. Partners owes the partnership, and partner owes to each other partner an ordinary degree of loyalty. True or false? False. Because every partner owes the fiduciary duty of loyalty. Fiduciary duty of loyalty means the absolute degree of loyalty, not ordinary degree of loyalty. Therefore, false. The partners may compete with a partnership as long as it does not harm the partnership through a policy. Policies. Because partners cannot compete with the partnership. Why? Partner has a fiduciary duty of loyalty to act in the best interest